Welcome, everyone. I'm Terri Austin, sitting in for Jesse Weber, and this is Law&Crime Now. We are covering all the top stories for you today, starting with the Washington State case where Susan Powell Cox was disappeared, frankly, and her husband said he had no idea where she was, and ultimately those two beautiful children that you see right there died in a horrific fire along with their father. And ultimately the grandparents sued these folks and the state, and there's a $98 million jury verdict for the grandparents because they're saying the state was negligent. We're also covering, you might have heard the case in New Brunswick, New Jersey. This is Judge Esther Salas. She was home, and she's a federal court judge. She's one of the only Latina judges in the federal court system. She was home with her husband and with her son, and a person posing as a Federal Express deliverer came to the door and shot and killed her son, and also shot her husband, and he was critically injured. She just recently came out for the first time, and she's actually calling for a law that would make it far more difficult to find the address of federal judges and have them be much safer. We also want to bring you up to speed on the Rayshard Brooks case. You may recall that police officer Jared Rolfe. Well, he was out on bail and he had a monitor. Guess what? He went to Florida on vacation, and now the prosecution is saying, we don't want you to have $500,000 bond. We want you to be back in jail because you have violated the terms of the bond. And so we'll see what happens there. The case you've all been waiting for, of course, is the Chad Daybell case. There were 2 days of preliminary hearing on Monday and Tuesday. You see Chad sitting there, and they had evidence. Multiple witnesses came on the stand, lots of authorities, police officers, FBI agents. But the main witness that we all wanted to hear from, of course, was Melanie Gibb, Lori's former best friend. Lori, of course, was married to Chad, and they are the ones involved with Tylee and JJ. And of course, those remains of those 2 beautiful children were found on Chad Daybell's property. So the judge, Farron Edens, he actually said, yes, there's probable cause here, and the case will now move forward. Let's take a look now. We had Melanie Gibb. Her boyfriend, actually, Dave Warwick, was on the stand. Let's pull up a clip and take a look at what he had to say during the hearing.
We're just talking about, I believe, Mr. Cox bringing JJ into Lori's house.
Yes.
Do you recall what time that was?
I don't recall it exactly.
Okay.
It was later in the night.
Okay. Was Chad Daybell there?
What's that?
Was Chad Daybell there at that same time?
No.
Okay. Let's talk about the morning of September 23rd, 2019. What did you do that morning?
I got up to get ready to go, then I went downstairs to say goodbye to everybody.
Okay. And who was there?
Melanie Gibb and Lori Vallow.
Okay. Did you see JJ there?
No.
Did you talk to Lori about JJ that morning?
I did.
What did she tell you about JJ that morning?
She said that he was being a zombie and climbed up on the cabinets, climbed up on top of the fridge, smashed her picture of Christ down, and then climbed up onto the upper cabinets and got between the top of the cabinet and the ceiling.
Okay. And then what did she tell you?
I asked to see him, and she just said that he was out of control, so she had Alex come and get him.
And
all right, that was David Warwick. Let's also take a look at what one of the officers had to say in the preliminary hearing.
Site number 2. It was a little bit more complex for us, I think, but it was the same process. There's a story to be told here at this grave, so we want to do the same thing. layer by layer, noting any significance. The difficulty, I think, for us, for this one, was the way these human remains were found. So it was kind of this, for lack of a better term, it was kind of a mass of dismembered human remains. Burnt, partially burnt. And so we did the best we could. It was kind of hard to recognize, like, what are we looking at here initially? You know, what is this? We know there's tissue here, there's organic matter here, and we just couldn't recognize what we were dealing with. But layer by layer, we ended up just excavating all around this mass of human remains. And we ended up excavating all the way around it. And at the very bottom of this mass, we find, this melted green bucket. And then to the bottom, the side of that green bucket, we eventually find a skull. And then to the side of that skull, we find a mandible with some teeth. Those are the significant things that you could finally see and recognize out of this mass.
Okay.
And so we did the team the best they could to kind of excavate around this and kind of tell that story. And again, we'd stop every so often, take photos, take scans, and document that excavation process, just like we did at the burial site 1, layer by layer. And then eventually, it came the decision point of, okay, now we need to try to lift these remains out of burial site 2.
What happened when you tried to do that?
So when the team tried to lift the remains, this mass out of burial site 2, it fell apart. So what ends up happening is just a removal of pieces into the coroner's body bag. And then once we get the pieces into the body bag, our anthropologist and the coroner essentially do, as best they can, an inventory of what pieces we have, so that I know, as the team leader, how much more do we need to look for in this grave? Because I don't want to leave at the end of the day with only partial remains and there's something else in there.
So that was FBI Special Agent Stephen Daniels. He's talking about when he found the bodies of Tylee and JJ. And burial site number 2 was Tylee's body, and it was a mass of dismembered remains. We have with us today the 2 people we really need to discuss this case. Joseph Scott Morgan, our forensic expert. Katie Smith, she's our trial attorney. I'm going to start with you, Joseph. You know I'm going to start with you. How did that testimony impress upon you, the fact that there were all of these horrible remains just taken apart?
Agent Daniels did a fantastic job, Terry, kind of breaking this down. He simplified it. And let me simplify it for our audience. There's a process that's referred to as stratification. And when bodies are placed into graves, you have this multiple strata. But let's take the big terminology out of here and just think of a big layer cake that kind of collapses in on itself. And so for every layer of dirt, sediment, debris that's been placed in there, and we're talking about debris from the fire pit here, you're going to have carbon deposits along with the body. This stuff gets commingled and kind of spun around. So they have to be very, very careful. Note what Agent Daniels said. When they attempted to lift the mass, which you're dealing with this organic mass out of this defect in the ground, it begins to fall away. And one of the problems that happens with this is because of this commingling, you'll have bits of evidence that kind of fall to the side. Now, this can be, he mentioned the melted plastic bucket, it could be charred wood, or it can be burned human remains. So you don't know what you have at that moment in time. So you have to be very, very careful, very meticulous. It sounds as though that this is something that Tylee, that is at least, that they started and just didn't have the wherewithal to finish. And I'm talking about rendering her remains down vis-a-vis this fire pit. because they know that they still have human tissue or some type of organic tissue to deal with. Some of it's going to be a bit recognizable. He talked about the mandible, which is the lower jaw. He talked about the skull, that was recognizable, but you don't know what else you're missing. And so every little piece, Terry, is part of the fabric of this entire story.
Exactly. I thought he did a great job as well. Katie, let me ask you. This is the probable cause hearing, and we know the charges against Chad Daybell have to do with destruction of evidence and also conspiracy to destroy evidence. Do you think that the prosecution had enough evidence here with this witness?
Oh, without a doubt. I mean, it's unbelievable how much overwhelming evidence there is against him. He has such a hard road to climb to defend himself in the criminal case. And this preliminary hearing is a really great preview for us to see the type of testimony that can be expected at trial and the difficulty that he has in overcoming this. He has a really tough job to try to beat these charges. I wouldn't be surprised if at some point he tries to take a plea.
I agree. Listen, this was really an incredible preliminary hearing, lots of evidence. Let's take a quick break, and when we come back, we'll have more.
I have a plan for retirement.
For college savings.
For investing.
I can see all of my accounts and my investments.
All my investments and more in one place.
I feel good about my finances.
Get free financial tools or talk to an advisor. Personal Capital.
Can your kitchen knife do this? How about this? Well, now it can. Inspired by the hit TV show Forged in Fire, is a once-in-a-lifetime knife. So sharp and so strong, it will cut everything in your kitchen, frozen or fresh. Forged in Fire's knives, surgical steel construction, and razor-sharp edge literally shatters the competition, so you can fillet your fish. Its professional handle won't slip, even chopping this frozen solid block of ice. And that torture won't dull its precision sharpness. Now you can get the Forged in Fire chef's knife for the low, low price of only $29.95. And when you order now, you'll get the Forged in Fire paring knife absolutely free. Order a second set of knives right now, and we'll give you free shipping on the entire order. And all Forged in Fire knives come with our 50-year guarantee. But you must order now.
Call 1-800-821-9245. 1-800-821-9245.
My son needs this drug. I hope it doesn't cost too much. I hope my insurance pays for it. Can you tell me how much this will be?
$67.
Sorry.
Wait, have you heard about GoodRx? GoodRx finds free coupons to help you save up to 80% on your prescriptions.
Wow. I had no idea.
GoodRx. Stop paying too much for your prescriptions.
Anybody can be a firefighter. Male, female, younger, older.
We have school teachers. We have leaders in business.
It's me, you, anyone that wants to be.
There is no typical firefighter.
Welcome back, everyone. We are actually reviewing what happened in the preliminary hearing of Chad Daybell. We know for a fact that the case will move on, but here is the closing argument by Rob Wood. He's the prosecutor in this case. Let's take a look at what he had to say.
I'm aware this court is very well aware of what the burden of proof is for a preliminary hearing due to the wide audience it reaches. Point out that Idaho criminal rule states that if the court finds that an offense has been committed and that there is probable or sufficient cause to believe the defendant committed the offense, the court must bind that defendant over to answer in district court. And so, Your Honor, just a brief recap. On November 25th, the Rexburg Police Department was notified of a missing child, J.J. Vallow. The next day, their investigation begins. What they discover in the course of that investigation is that there's another missing child, Tylee Ryan, and they discovered that the last day she's seen is September 8th in Yellowstone National Park. They find evidence that on September 9th, Chad Daybell sent a text to his then wife, Tammy Daybell, at 11:53 in the morning about burning limb debris and burying a raccoon in his pet cemetery. That very same morning, Alex Cox's phone pings in that same area, that pet cemetery area on Chad Daybell's property. On June 9th, Tylee Ryan, who we've identified through DNA, is found buried, burnt, dismembered portions of her in a green melted bucket, buried with animals in the pet cemetery. Through that investigation, they find that the last known sighting of J.J. Vallow was September 22nd. The last known sighting of J.J. Vallow was September 22nd. Similarly, on September 23rd, Alex Cox's phone pings on Chad Daybell's property. Near those pings, where those pings are located on the north side of Chad Daybell's property, on June 9th, JJ is found, wrapped in a garbage bag with another white garbage bag wrapped around his head, bound in duct tape.
That was the closing argument of Rob Wood. He's the prosecutor for this case, and he was talking to the judge. There's no jury here because it's a preliminary hearing. Katie, this one is for you. I think that he did an excellent job. I know some think that he did not do enough because he didn't bring enough evidence forward. And there is an argument to be made that he did not tie this, I think, humongous evidence to Chad, that he had the bodies of Tylee and JJ. He had the pings of the phone for Alex, and obviously we all know that Alex is the uncle and he was the one who was there. Do you think that Rob Wood tied this all together enough? Obviously we're moving forward, but if you had to do it, did it tie together for you as far as Chad was concerned?
The simple answer is yes, because what we need to remember and to remind the viewers that a preliminary hearing is a totally different standard. The showing is probable cause, and probable cause is a low bar. You know, we have beyond a reasonable doubt is up here. Probable cause is way down the bottom. It's just an indicia that there's criminal activity afoot, and obviously there needs to be that causal tie. Many times prosecutors keep a little bit in their pocket because they don't want to show their entire hand for what's going to be coming at trial. So I think that the prosecutor here weaved that fine line. It was enough, but it wasn't too much to really blow out of the water all he has up his sleeve. So I think it was a well done job.
Katie, we are two peas in a pod. That's exactly what I think as well. Why show all your cards now? Wait till you get to trial. You know you have a low bar and you know you can get over it. Joseph, I'm going to ask you a question. What else could the prosecutor have done to tie Chad into all of this? Clearly, Alex is involved. We have the pings. But from a forensic expert point of view, what else could we have done?
You know, I've given some thought to this. I think that they went far enough, as Katherine had mentioned. However, I think, you know, and I think that it's really cool that you guys are talking about how they're kind of vesting their cards right now before, you know, moving forward with the actual trial. One of the things that we will see are going to be forensic tiebacks. As gruesome as it is, please keep in mind that we're dealing with a case of dismemberment here. And where you have dismemberment, you have tools, okay? Now, whoever possessed those specific tools that engaged in this act of dismemberment is going to be a specific forensic tieback, all right? So if we're thinking that Chad possesses tools within that shop, remember you could see the shop not too far away from there. We're talking about saws, any other manner of instrument that could have been used. And also another key thing that I think, because fire is involved here, I'm really curious about the origins of the accelerant that was used. I'm hoping that on whatever clothing that was left on Tylee's body, or perhaps that green melted plastic that you have there, maybe they were able to source some sample of accelerant. And if that is the case, there will be a chemical tieback relative to the structure of the fuel that was used in order to start or initiate this fire, whether it's kerosene, gasoline, whatever the case might be. That's going to be key. So it's all those little details that you guys so well put that they don't want to show yet. I think they did a sufficient job. Also, electronics is going to play a huge part in this case because, I call him Uncle Alex. I think that they're going to try to hang all of this on Uncle Alex. They're going to be talking about his phone moving forward. And that's going to be key because you're going to have all of these experts. We're going to learn in this trial so much about forensic data analysis and all that sort of thing. I can't wait. It's going to be fantastic.
It is going to be fantastic. Let's take a listen now at what John Pryor had to say during his closing. Remember, he's the defense attorney. Let's take a listen.
Testimony, according to this prosecuting attorney, is that Mr. Daybell was married to Miss Vallow. That's doesn't provide anything. Not only doesn't it provide an overt act, it doesn't provide an agreement. Marriage is not an overt act towards a conspiracy, and marriage is not an agreement to conceal or to conspire. In addition, what they have is Mr. Daybell making a comment to a police officer. That is not an overt act to conspire or an agreement to conspire as well. And then what they have is they have an obscure text message that says, I burned some items in the fire pit and I buried a raccoon. Now, they can suggest whatever they want with that, but there's been no indication of any evidence that this act took place on the 9th or the 22nd or 23rd or whatever day it was. And quite honestly, Judge, they don't even come close on the concealment of Tylee. They don't even come close on the concealment of JJ. And the conspiracy, they lack the agreement. And quite honestly, Judge, if this is what the evidence is in terms of an overt act, I would submit to the court that I understand the burden in a preliminary hearing, but they aren't even close on the conspiracy in either suggestion that, in either case, in regards to an overt act plus an agreement. I'm respectfully asking the court to dismiss the charges. They haven't met their burden, and I don't believe they have provided any near the type of evidence that is necessary to even overcome that small threshold. Thank you, Your Honor.
The court finds, after reviewing all of the testimony that has been presented here, as well as exhibits 1 through 31, as well as the argument that has been made by both the state's defense and the state's attorney and the defense attorney, the court finds that the state has met its burden of probable cause, and I find that there is probable or sufficient cause to believe that the defendant, Chad Daybell, committed the offenses counts 1 through 4 as designated in the amended criminal complaint. I will bind the defendant over to the district court, and there will be an arraignment set on August 21st at 9 a.m. That will be in front of Judge Boyce. It's my understanding that will be held remotely via Zoom, but I will leave that up to Judge Boyce.
Katie, we just heard the judge say, yes, there is probable cause, but I have to admit, when I was listening to Pryor and doing his closing, it worried me a little bit because he talked about the fact that there was no agreement for the conspiracy. Remember, we have the 2 counts of concealment, altering, and destruction of evidence, and 2 counts of conspiracy for the same thing. And the conspiracy charge, they did not show anything about an agreement between Chad or Lori or Alex. Were you worried about that at all?
You know, that definitely is the weakest of them all. And when I was hearing him, you know, he did a good job. He shot his shot, and I was a little concerned. Conspiracy is always a really tough one to show. But here's the thing. They always say in law that possession is so much of the law, right? And here we have these bodies on his property, and that speaks so much, as well as these ambiguous communications that we're going to see fleshed out in much more depth during the actual trial. So for the purpose of a probable cause analysis, which I cannot emphasize enough, is just such a different standard than beyond a reasonable doubt, I'm glad we made it past that line.
I'm glad we made it past that line, too. It would have been really problematic had we not made it past that line. Joseph, let me ask you this question. Did you see the grandparents who were sitting there at the preliminary hearing in the back when the judge was actually reading that we are going to move forward with this case? Did you notice their actions towards each other. They looked very happy that, in fact, we were moving on. But, you know, they were surely, I think, upset at the whole situation.
Yeah, as a matter of fact, from a personal perspective, my wife and I were watching the first day, and they panned over to the grandpa, and he was weeping. And my wife began to scream, "Take the camera off of him! Take the camera off of him!" Because it's gut wrenching. But you know, we've watched this over and over in so many trials, Terry. You know, over the years, and to see that final glimpse of Grandpa there. They knew what direction this was going in, and they were able to, you know, I hate the word closure because I don't think it's a real thing most of the time. You always, you know, when you're dealing with death, which I've done my entire career, no one ever really gets closure in something like this. You have small victories along the way, and that's what they have to be heartened by, I think, and moving forward and hoping that they're going to get justice, whatever that means at this point. But to flesh this thing out and really find out what happened. And boy, in the next couple of months, I'll tell you what, people better hang on to their hats because this trial is going to be something to see. I don't know that we've ever covered anything like this. It is so very complex, and there's going to be a lot of players coming in and off the stage throughout this thing.
I couldn't agree with you more, Joseph. And the big question is, when will we see those murder charges? Let's take a quick break, and we'll be right back after that. We are going to take you to the Susan Powell case out in Washington State. There was just a verdict, a $98 million verdict for the grandparents. Let's take a look at what the Cox family attorney had to say during those closing arguments.
At 12:15, the first 911 call ends. We know at this point the boys have been doused in gasoline, but there's no fire. What's going on? At 12:24, Elizabeth Griffin Hall makes the second 911 call. The house has just caught on fire. We know the boys are still alive because they died of carbon monoxide poisoning with soot in their windpipes. It's 21 minutes and 44 seconds. If Elizabeth Griffith Hall is accurate in her estimates. We know that they were conscious for some time because, ladies and gentlemen, they swallowed gasoline. It was in their gastric content. It was in their blood. It made its way all the way to the vitreous of the eyeball. The forensic experts all agreed you can't swallow when you're unconscious. Now, Dr. Nelson, the state's expert, said, well, it must have gotten in some other way because it wasn't in the urine. But ladies and gentlemen, if you look at the toxicology reports, what will you find? The urine was never tested for alcohol. Dr. Nelson is flat wrong. I suggest you pay attention to the actual ME who did the autopsy and told you most likely this got in their system by swallowing. I suggest you listen to Dr. Weck, who agrees with the ME's conclusions on it. That slow curtain, ladies and gentlemen, of consciousness, we know it overcame the voice at some point. And only you can decide when, thank God, they finally hit a level of unconsciousness where the pain went away.
Remember, this is a civil lawsuit here. We have a suit that is being sued and pursued against Washington State, and they're being sued for negligence. Joseph Scott Morgan, I have to ask you, because of the horrendous nature of this underlying case where the two boys were doused with something and set on fire, and the house was set on fire, and ultimately they all perished in this fire. What are your thoughts about all of that? How could this have happened?
my friends that are in the legal field that deal in civil cases, one of the go-to markers that you look for is level of pain and suffering. Terry, I have to tell you that out of all the many cases that we cover, this fits within those parameters like you cannot believe. The attorney that was just speaking was talking about the degree to which these children were impacted by this, and it goes to torture. I think they're made possibly to ingest this accelerant in addition to having it poured all around them. You're finding it in their gastric content. That's not normal. Okay. Now you'll get inhalants when things vaporize after, things are burning and this sort of thing. You begin to inhale that residue, and you can find it that way. You'll get soot in the airway. He talked about that. But this is at a completely different level, Terry. And it's absolutely horrific. It is beyond the pale. I think that, the grandparents were right in bringing this case and there are a lot of players involved here. DFACS, in particular, what I refer to as DFACS, Department of Family and Children's Services. Yeah, I think that they need to be nailed on this, and they were sufficiently, I think. I hope that this actually draws attention. How many years have we talked about this over and over, the failure of these agencies to protect these little babies like this, and then the beat goes on, and I hope that they need to suffer pain here.
I could not agree with you more, Joseph. And Katie, Joseph actually just raised the issue I wanted to ask you. They said it was negligent because DFACS did not go to the house enough, because when they went for the supervised, visit, they didn't go in. All right, so let's quickly go to a clip and take a look at what the ADA had to say in the case.
This will be the only and final time that you hear from the state in this matter until we have the opportunity to talk to you after you've come back with whatever decision you're going to be making. Now, we would all recognize that we've been on a very long road together here, started back in February. And all this time, in order to address a very tragic incident, one which most of us will never forget, one that was not foreseen by the state. Now, why do I say that? And I say that because of what is occurring is what we would refer to, and you've heard throughout the trial at various stages, hindsight biased, armchair quarterbacking, second guessing. You've heard throughout from the very beginning an opening statement, spinning of what the actual evidence and facts is in this case. There's no ifs, ands, or buts that it was a very tragic matter. But the state, and we're going to show you in a moment, that the state took this very serious. They did their job, they followed their policies. And what we're going to ask of you is to evaluate this case based upon the information that was known at the time, and that the state's reliance upon professional evaluators, a knowledgeable court, a judge who was overseeing these proceedings.
So that was the Assistant Attorney General, and he's representing the state. Katie, let me ask you the question that's on everyone's mind. A $98 million verdict. That's a lot of money, and it was shown, obviously, that there was serious negligence. Do you think that that will be appealed or overturned in any way, shape, or form? Do you think it was the right result?
The minute I heard the value of that verdict, I got scared. And that's because all verdicts need to be sustainable. They need to be supported by the evidence. The great news and the sad news is that there is so much evidence of the boys' conscious pain and suffering. So we look at their conscious pain and suffering, we look at how young they are, we look at how much life they lost. So all of these things are taken into calculation when there is, I'm sure, going to be a remitter or a request that this amount be reduced as a matter of law. So in short, there's a lot to support a huge verdict, but 98 million, I unfortunately imagine is going to be reduced.
I know. I think that you are absolutely right about that. Joseph, let me ask you this. The mom is still not found. Her remains have not been found, and she still hasn't been declared dead. They have 10 years, I think, before in this state they can declare you dead. What do you think the impact of that was on this jury verdict for 98 million?
Now, I got to tell you, what you're talking about is ultimately the eradication of an entire family unit as a result of failure by the state agency to take care of this family unit. If they had, all this training that they go through day in and day out, months of training to look for, signs of neglect and abuse and all these things that you hear about in these classes that they go to. And, many of these folks, teach the classes that some of us have to attend or have attended in the past, in medical legal death investigation and law enforcement. And they can't even abide by these things that they set forth. And it is horrible. I mean, this is the ultimate end. And that's the reason I said, I used the word pain. They need to be, the state needs to be pained over this because nothing is changing. And I'm looking from a national perspective because we see so many of these cases. It is a wake up call to better vet who they've got in these positions of authority, how they're being trained. And, and look at these precious little angels that are in their charge. Ultimately, they're the ones that paid the price.
Absolutely. Listen, I stand corrected. Actually, 10 years have passed since Susan disappeared. She disappeared in 2009, and this is past, 10 years. It's 2020. She was declared dead in November of 2019. So there you have it. Let's take a quick break, and when we come back, we'll talk more about this and other cases. Welcome back, everyone. We are now going to the case in New Jersey where Judge Salas, her family was shot, her son was killed, her husband was shot, he was critically injured, he's still in the hospital as far as I know. And we found out that, there was a video of the judge, and she just recently came out to talk about what happened. Let's take a look at what she had to say.
Daniel and I went downstairs to the basement, and we were chatting, as we always do. And Daniel said, "Mom, let's keep talking. I love talking to you, Mom." And it was at that exact moment that the doorbell rang. And Daniel looked at me and said, "Who is that?" And before I could say a word, he sprinted upstairs. Within seconds, I heard the sound of bullets and someone screaming, "No!" I later learned that this monster who had a FedEx package in his hand opened fire. But Daniel, being Daniel, protected his father. And he took the shooter's first bullet directly to the chest. The monster then turned his attention to my husband and began to shoot at my husband, one shot after another. Mark was shot 3 times. Currently, federal judges' addresses and other information is readily available on the internet. In addition, there are companies that will sell your personal details that can be leveraged for nefarious purposes. In my case, the monster knew where I lived and what church we attended and had a complete dossier on me and my family. At the moment, there is nothing we can do to stop it, and that is unacceptable. My son's death cannot be in vain. which is why I am begging those in power to do something to help my brothers and sisters on the bench. Now, more than ever, we need to identify a solution that keeps the lives of federal judges private. I know this is a complicated issue, and I don't pretend to know or have all the answers. But together we can find a way. Let's commence a national dialogue. Let's work collaboratively to find a solution that will safeguard the privacy of federal judges. Let me be clear and tell you firsthand, this is a matter of life and death. And we can't just sit back and wait for another tragedy to strike.
Katie, I'm going to ask you a question about this video. It was very difficult for me to watch it as a mother. Every time I see it, I get very upset. It was hard for her to talk about this, but I'm glad she came out. This is the question. Do you think there will be some success in what she's asking for? She's asking for stricter laws as far as privacy is concerned. What is the chance of that happening?
You know, when I first heard this video and saw it, I mean, it's so moving, right? It was really from the heart and very hard to watch. What she went through is horrific. But the first thing that I thought of with respect to privacy is really what can be done. I know she had mentioned that there are, you know, basically investigators that people pay to get personal information. That is a reality. And federal judges are federal employees and they're public figures. And obviously, this stuff shouldn't be readily accessible at like an easy keystroke, but there's not that many ways to really hide that information. So I don't know what real solution can come from this, as heart-wrenching as it is.
I agree. It's really very heart-wrenching. All right, let's switch gears now to the Rayshard Brooks case in Atlanta, Georgia. We know for a fact that Rolf, who was the police officer, was confined with a monitor, and he ended up in Miami, and now the prosecution is saying he should not be out on bond. Let's take a look now and see. Okay, so there's Rolf there, and I'm going to ask you, Joseph, what are your thoughts about the fact that Rolf went to Miami? I mean, he's saying that, and his attorney is saying that it didn't say in the order that he couldn't go out of state. I guess he went to, you know, Daytona Beach or somewhere on a vacation. And they're saying that it didn't specifically say he couldn't go on vacation. But what are your thoughts about that? I mean, clearly they're supposed to stay close to home and not go out of state.
He's a police officer. He should know better, or was a police officer. He's got too much of an intense spotlight on him to do something like this. Because it's going to upset both sides in this pending litigation relative to this case, and it can compromise the integrity of the case. He should know better than to do this. And now, look, I can only imagine he's under pressure, whatever the case might be. Maybe he needs to go somewhere and, I don't know, clear his head or whatever the case might be. This was the wrong decision to make, because I can tell you, just, moving forward, this is something that will be brought up in the future. And that's why I say, as a police officer, you should know better. You're given a directive not to leave a location. You're supposed to be monitored, and you do it anyway. It's a problem.
Yeah, I mean, that's a very good point. Katie, let me ask you this. Do you think that ultimately that bond will be revoked, that he will have to go back to jail because he ended up violating, or at least it does seem as though he ended up violating the terms of the probation?
I do. I actually think that legally it's going to be a violation and that he unfortunately will have that revoked. But I think most importantly, this is ridiculous from a PR standpoint. I would be just so angry if I was his attorney. It just reeks of this flippancy with such a serious effect. Or offense that he's going on vacation. There's just so many things wrong with what he did. Former police officer should know better, but common sense just dictates don't do it. So I think that they're really going to throw the book at him.
Right, and we've just gotten word that the wife actually was saying that she was baffled that this happened and how could it happen, and she's hurt by this. And do you think, based on that, Katie, that the judge will ultimately decide that Rolf does have to go back to jail?
I do. I think it really depends a lot on the arguments that the attorneys are going to make and how specific the order was to stay close to home. But I tend to think, as we can see with, for example, the Cohen case here in New York, when people who are out and are given some restrictions and given their limited freedom, once they flout those court orders, the court is just not as generous. So I think that he's going to get a pretty strict talking to by the judge and have that revoked.
Exactly. Do you think, and this is my last question to you, do you think that it will have an effect ultimately on the case in whole?
Yeah, I had to think for a second because it really depends what comes out, right? It depends if they are allowed to bring this up during the actual criminal proceedings. A lot of times these are made in motions in limine because, of course, the defense attorneys don't want this coming out. They're going to say it's completely irrelevant to the underlying charges, and it makes their client look bad, so they don't want it out. That goes back to my PR vibe here. It's just really bad facts because it looks like he's not taking this seriously. So if it comes in, it's going to negatively affect it, but I think the defense is really not going to try to get it in.
Right. That's interesting. Listen, I am so happy to have had Joseph Scott Morgan, our forensic expert, Katie Smith, our trial attorney, giving us such excellent advice. You've given us all of the legal analysis that we need on all of these cases, and I appreciate your being here. And thank you, viewers. You are signing off tonight. We are signing off. And, stay tuned to Law and Crime.